Hey everyone, so we're back at it again for another episode with you. Today we're discussing with attorney Antoine Marshall regarding recent Supreme Court cases and how it affects you personally. I'm sure that you're going to probably have a good time enjoying this discussion, and we're looking forward to you participating and sending in your questions and of course enjoying the comments that myself and Antoine have. So hope you enjoyed today's discussion. So here we go. And without further ado, let's go ahead and add on Mr. Attorney Antoine Marshall. What's going on, sir?
How you doing today, Otis?
Blessed and highly favored, man. Just today is going to be a good day. Why? Because I think people tend to we're so numb to the actual news that's going on today that sometimes we get kind of get blanked over. And of course, bringing attention to actual things that affect you and your everyday life is something that is absolutely needed. But you know I've had you on here before and you've always bring a great insight to the discussion. So of course I brought you back again, and it's something that I appreciate, and something that I'm sure you appreciate as well, getting a chance to talk with us. So but before we go into the discussion today, I'd like to have you at least talk to us about who you are, because some people may see you for the first time. It's like, who's this bearded dude that he thinks he knows law? Does he even know what the hell he's talking about? I think people will believe that you do know what you're talking about, because typically I don't pick up bad guests, and the fact is I do my research on who the person is. So go ahead and just share with us your background and who you are and all those different things with us, man. Thanks.
No, not a problem. Well, first thing, thank you for having me back on. I always appreciate getting a chance to come and interact with your audience. So as far as who I am, my name is Antoine Marshall. I am a practicing attorney here in Raleigh, North Carolina. I've been licensed since 2012. I began my legal career with Legal Aid of North Carolina, helping low-income individuals, mainly in the areas of housing, so mortgage foreclosures, landlord-tenant, government benefits, things like that. I now own and operate my own practice where I do bankruptcy law, landlord-tenant law, and estate planning. So if you don't have an estate, very important that you get one. Discussion for another day. But beyond that, beyond practicing law, I think my passion is really for public policy. I've been very involved with policy and government. I've worked in 2 congressional offices and for the North Carolina and South Carolina state legislatures. I've also run for office myself, and I've helped on campaigns at a local, city, state, and national level.
Okay. So, I mean, we got it, man. You've got a good background as far as the legal side of town. What did you talk about really? Who's Antoine the person? I mean, yeah, I understand you've got the legal background, but who are you the person, man? I mean, let us know something.
I mean, I'm just a regular dude. I've got my wife. She's an educator. She works for the Detroit public school system. She's got a PhD in education policy. I've got 2 daughters, age 4, and then my youngest daughter will actually be turning 3 in 10 days. So she'll be celebrating her birthday. So that's a big thing.
Happy birthday.
Yeah. Other than that, I mean, just regular interest. I go to the gym a lot, and it's killing me that they're closed. Yeah, that's who I am.
I got you. So the gains are gone, but still the brain remains.
Gone. Yeah, the gains are gone.
I hear you, man. Hey, it's something where every day I see people coming on here, who may have the legal background and education and who do share their points of view on things, but you don't really tune in. You don't really pay attention to them because maybe their delivery sucks, their communication style sucks, but the way how you communicate things, the way how you share and educate us and really break it down to super common sense is something that is very consumable, and it's something that's appreciated. And that's the reason, one of the main reasons why I brought you on here. Like, where did that passion come from about educating folks and breaking things down so simplistically that common folks could understand?
So, I mean, I got involved in politics when I was in college. I actually started my educational career as hoping to become a doctor. So I started as a biotechnology major. My goal was I just wanted to help people. Like, that was always my focus. My drive was I just wanted to help people. So I wanted to be a doctor. I did a couple of internships in college, did some work as doing some cancer research, did some work at the podiatrist's office, realized I didn't like the research or clinical side of practicing medicine. That's when I had the opportunity to go to DC. I interned in the office of Congressman Clyburn, who is a state representative, U.S. representative from South Carolina. That's where I fell in love with politics. And I saw, like, this is how I can really help people. And from there, I was kind of all in, both feet in as far as, this is what I want to pursue. The campus that I went to at the time, the college I went to at Claflin University, the campus wasn't very political. It was a small HBCU in Orangeburg, South Carolina. It wasn't really very political. And it was right around time Barack Obama started running for office. I got very involved in just trying to explain to people, like, hey, this is the process. This is, this is what's going on. And I think even after that, staying involved in politics, looking at local government, state government, I realized there's a big disconnect in what people understand and what actually goes into, what goes on the ground. Working with candidates, I see it all the time. Like, for instance, I was a campaign manager for a city councilman who was running in Raleigh. And we went to a candidates forum where the audience had a chance to get up and ask questions. And I remember somebody getting up and asking him, what's your view on gay marriage? And I was like, I'm thinking to myself, okay, who cares? I mean, not that it's not an important issue, but he's running for city council. There's nothing he can do about that anyway. So, if you're going to ask this kind of question of who's going to be representing you in these offices, there needs to be some understanding of what these offices, what the powers of these offices actually are. And that's what I think is the big disconnect. I mean, we saw it during the Obama presidency. Everybody was like, hey, we got a Black president now. And then 4 years later, they're saying, well, what has he done for us? Well, I mean, he did what he could with the Congress you gave him, So, I mean, it's understanding, where these policies come from, what levers do you need to pull to get the change you're seeking? The president has a lot of powers, but they're limited in scope. Your Congress has a lot of powers, but they're also limited. Your state legislature have powers, they're limited. Like, you need to figure out, if you're trying to get X done, these are the people you need to talk to, and who you need to pay attention to.
Gotcha. So I'll tell you what, especially during the past 3.5 years of Donald Trump's presidency, I think a lot of folks have really been jumping on and just really wanting to understand, and really people have become more politically involved.
Yeah.
The past 3.5 years, and it's maybe for the betterment. People need to be more educated and understanding. Yeah, I mean, here's the thing. I try to be apolitical on this discussion panel, even though I may have a certain political sway, left or right. Doesn't matter. I've got to be apolitical on this discussion. Yeah. So I think it's a good thing that we're more involved, we're more educated on all these different things and how they affect us in our everyday life. We've something that's unique to me, because I grew up in New York, but I'm not originally from the United States. I'm from the Caribbean, Trinidad and Tobago. It's very different down there. Yes, we have a president, but we also have prime minister, and we have chambers of Congress and parliament and all those different things. But it's kind of different here in the U.S., where we've got 3 equal legislative branches and 3 branches of government, I should say. And, that's really what we're kind of talking about today, of how this one branch of government, how its rulings affects us today. Can you kind of give us like not necessarily a Schoolhouse Rock version, but can you kind of break down to us, what exactly are the roles that each part of these branches of government play?
Not a problem. So The legislative branch was originally designed, the legislative branch was designed to be the most powerful branch, I guess, most powerful in a group of equals, I would say. That's why it is chapter 1 within the article 1 of the Constitution. But the legislative branch, they have the authority to write laws. So when you think about a lot of the laws that are in place, a lot of them are written by the legislative branch. And, breaking it down even to the state system, most states have those same 3 branches of government. Your state legislator, again, write those laws. So, when you start talking about, well, what is illegal? Murder is illegal. Okay, the speed limit is this. Who sets those rules in place? It's the legislative branch. They also have the ability for taxing and spending. So how much you're being taxed, how much is being spent, all of that goes to the legislative branch. The executive branch is designed for enforcing laws. So basically, the legislative branch says, these are what the laws are. The executive branch's job is to enforce them. A lot of the way that the executive branch works is it's done through administrative agencies. So you think about, the Department of Energy, the Department of Commerce. They can put some administrative rules in place to govern and basically make sure that Congress's laws are being enforced. So, for instance, Congress passes the Clean Air and Water Act. Okay, well, now the environmental department gets the chance to enforce those by saying, okay, companies, you can't dump waste here. Okay, auto manufacturers, any cars you make have to have a certain amount gas mileage,
emissions, basically, and all those things. Yeah,
exactly. Basically, to implement and enforce those laws. The judicial branch their job is basically to be the referee. What becomes constitutional? All of our government, basically from the state and federal, are given through all the powers of the government are given through the Constitution. And then we also have the Bill of Rights, which reserve rights for individual citizens. And it's the judge's job to make sure, number one, if there's any dispute as far as what a law is or what a law says, then it's the judicial branch's job to determine whether or not it fits a legislative statute or administrative statute or not, and then also weigh in on whether or not those statutes meet constitutional muster. So they may come in and say yes, the legislative branch passed this statute making, something illegal. Jim Crow is now legal according to statute, but the Constitution says that you cannot do this. Therefore, the laws of the legislative branch passed are now invalidated. So in a nutshell, that's essentially what the 3 branches of the government are designed to do.
Awesome. So I know we have some recent cases, and we're getting to the meat of this sandwich. Like, hey, let's talk about some of these recent cases and how it may affect, maybe a viewer of our discussion today, maybe a family member of our discussion. These are things that people need to know the answers to. And I know you've got several cases that you wanted to highlight. So let's go ahead and talk about the big one, the first main big one, the DACA ruling that recently came about. Let's talk about what exactly and how exactly that affects us.
Okay, so right now the Supreme Court, they're finishing up their session in the next couple of weeks. So I think they have maybe 3 or 4 more cases that they still haven't issued a decision on. And they're also deciding on what cases they're going to take the next session. But one of the big ones that came out a couple of weeks ago was the DACA decision. It was the Department of Homeland Security versus the Board of Regents of California. And basically what happened, we remember that President Obama put in place the DACA program. And I think this was back in 2012, if I'm not mistaken. But basically, the DACA decision was an offshoot of the DREAM Act. So just a quick, historical breakdown on this. Congress and the quote-unquote Gang of Six, there were 6 bipartisan senators who came up with this plan as far as the DREAM Act. And the discussion was based on individuals who were brought to this country as children, who are now adults. So, if you're brought to this country at, 3, 4, 5 years old, you're now 22. And, technically you are not a citizen because you were not born in this country. Therefore, you don't have, birthright citizenship. You were never naturalized as a citizen. And the way that our immigration laws are designed, you can't apply for citizenship while in the country. You would have to go back to your home country and get on the wait list, which could take up to 10 to 15 years before you could come back. So the question was, what do we do with all of these people who were brought here as kids, through no fault of their own? They're adults now, but they're also barred from things like getting a driver's license, getting a job, going to college, joining the military. But it's kind of immoral to send them back to a country that they know nothing about because they never spent any time there. So those were the Dreamers. And in the end, Congress never passed that bill. They discussed it, they debated it, it came close to passing, never did. So the Obama administration, they came up with DACA, and essentially deferred action for childhood arrivals. And basically what DACA did was it allowed those individuals who met the same criteria that was under the DREAM Act, had to be brought to this country at a certain age, before a certain time period. As long as you went to the federal government, you went to the Department of Homeland Security, and you gave them information about, where your name, who's in your household, your job, you gave them all this information that a lot of illegal immigrants are afraid to give to the government because they're going to use it to deport you. As long as you give them this information, you pay a fee, every 2 years you re-register, they're not going to pursue any immigration action against you. You're not going to be deported. Gotcha. It also gave them certain rights as far as being able to get a driver's license, getting a work permit, to be able to go to school or in-state tuition, things that are very important that if you're not a citizen, you worry deeply about. Where am I going to go to college if I can't afford in-state tuition here? So that's essentially what DACA did. And it worked for about 800,000 Dreamers. It was their lifeline to be able to continue to live a normal life and not have to look over their shoulder, being threatened with deportation. When Trump came into office, one of his first decisions, September 2017, was to eliminate DACA. Department of Homeland Security eliminated the program, and it brought a lawsuit from the California region, Board of Regents in California, basically the California university system. So eventually that case wound up in the Supreme Court. Cases always take a while to get there. 3 years outside the realm of ordinary for cases to end up in front of the Supreme Court. And what the courts did was they basically struck down Trump's invalidation of DACA. Now, the interesting thing is how they did it. Nobody really argues that the president does not have the authority to eliminate DACA. He does. DACA was an executive order. And so you can get rid of an executive order by Congress passing a law or through another executive order. So Trump does have the authority to get rid of another executive order. The problem is that the Trump administration was very sloppy in how they did it. And that's why this ended up getting overturned.
What do you mean by sloppy?
So as we talked about, as far as regulations and, the executive order came with regulations that the Department of Homeland Security implemented. The problem with this is that if you're trying to issue any kind of administrative policy, there's a process to that. It's called the APA, the Administrative Processing Act, I believe is called. I know the APA is the shorthand for it. So excuse me, I don't know. But you have to go through that process. And part of that process is making sure that there is not an arbitrary and capricious manner for why you are doing something. And so
you said arbitrary and capricious, like,
yes.
Does that mean like you have some sort of ill will intent in what you're doing?
No, not even the ill will or intent. It just has to be sound. So I can't say, I'm going out, I'm trying to think of a good example. So it just has to be somewhat sound. So I can't say, I'm going to go inside because I'm going to get a tan. Like, you don't get a tan going inside, so that can't be the reason for why you're doing that. So that's kind of the process. And so what the Trump administration said, DACA is a very, very popular program politically. About 85% of the country, Democrats, Republicans, they're on board with it because, again, how do you send somebody who's 25 years old back to a country they hadn't been to since they were 3 years old? They didn't ask to come here. They didn't ask to break immigration laws. But now, they may have kids. Some of these people, are in their 30s. They may have kids. They may have college degrees. I mean, they have lives here. So it's a very popular political program. So the Trump administration didn't want to touch the political guardrail that it, a third rail of politics of what DACA is and why it's so popular. So they tried to get rid of this by saying that, oh, well, the courts find it unconstitutional anyway. The courts find it illegal. And they also made some claims about, the benefits that these people from DACA will receive. And that was the grounds behind why they said that they were going to eliminate the program. There was a 2017 memo from the then DHS Secretary, Elaine Duke, as far as why she was going to eliminate the program. And again, it was sloppily drafted. It didn't really explain, and Chief Justice Roberts, who actually wrote the decision, came back and said, even the things that they were claiming, they said, oh, well, DACA recipients, they can collect on Social Security and Medicaid and get driver's licenses. Okay, well, the ultimate goal of this was to prevent them from being deported. So if your concern was over Social Security, Medicaid, and all of that, you could have eliminated that and still kept them from getting deported. Like, why are we invalidating the entire program? If you said that this is the part you have an issue with, why are we getting rid of the entire program? And then they also kind of hit them on the court. We're getting rid of this because the court said it's illegal. And the Supreme Court came back, they didn't really make any decisions as far as the legality of it, but nobody had ever challenged whether or not DACA was illegal. So it's kind of like, you all made up this reasoning that, you're saying that we said it was illegal. We never said that. And then you're also saying we're getting rid of it because of all these benefits that you say it produces, when it doesn't, when, you could have taken a different, slice of the apple as far as trying to limit the program. So for those reasons, they ended up striking down that decision. So DACA is here to stay. But one of the things, if you are, in support of DACA and support of the Dreamers, one thing you still have to be cautious about was that they just struck down the Trump administration for saying, because basically it was a sloppy decision. The Trump administration could come back and do it again. They just got to do it the right way. So, again, we know that the Trump administration or any administration has the ability to overturn the executive order for DACA, and they could do it. They just have to do it the right way. And what the Trump administration did was the wrong way. So it's kind of a short-lived victory. Like, yes, the program's here to stay, which is great, especially for those 800,000 Dreamers, but at the same time, it's not a long-standing victory. Again, the Trump administration could write an executive order tomorrow to get rid of DACA again if they do it the right way. They probably won't, just because, again, we're coming up on a campaign that is a very, very politically, popular program. They're probably not going to touch it with a campaign riding on it. So.
Got it. Hey, and I think, as always, you've kind of explained it very well as far as how it affects us and what does it mean and all those different things. So I appreciate that. I do have some comments coming in, and it's not necessarily connected to the DACA decision, but let's go ahead and just still put it up anyway so that people could see. And I think someone is going to be reaching out to you fairly soon. The first comment that I see on here, it comes from Mr. Sean Lanier. He is your frat brother, by the way. So shout out to y'all, I guess. Shout out to y'all. I don't know. But his comment is, we'll be reaching out in discussions now about the upcoming West Point Leads event in Detroit this fall. So I'm thinking he's going to try to contact you through your wife's connection to possibly, build the pipeline for super qualified, military officers that she may have some access to. So be on the lookout for that. It's coming.
Not a problem. Definitely. I say.
Awesome. We've got one from Miss Merrick Brady. Yes, my homie Antoine Marshall. Merrick, how you doing? How you doing, Merrick? She's doing good. We've got one from Miss Kalechi Okoro. She says Raleigh, as in, that's where you're from. She said she wants to be you when she grows up.
Nah, you got to be better than me.
Hey, it's all good. It's all good. We've got folks tagging other frat and friends. He said, check out this discussion frat. I know you will enjoy it. And we've got one from, Masoro. She says she's following, and she says, thank you for sharing this information.
You're welcome.
We've got one from Kelvin. Man, y'all just showing up today, ain't y'all?
That's what we do. I tell you that. I appreciate the love, Fred, and the support.
Hey, I mean, we just throwing hand signs around. Okay, I see y'all. I see y'all. Hey, I appreciate. Hey, it's always a good thing when your frat brothers and people who support your networks, support the role that HBCUs and NPHC organizations
Yes, indeed.
do play in today's role. Let's jump into the next Supreme Court decision that's out there, and I'd like to talk a little bit about the Electoral College decision that just came about. What is that called?
They're called faithless electors.
Okay.
So I say trying to wrap the history up pretty quickly. Most of us are familiar with the Electoral College system. We run into it every 4 years when there's a presidential election. Mm-hmm. And I think there's a lot of misinformation and misunderstanding of what the Electoral College is and what it does. So back when it was originally created, it was a group of wealthy, powerful landowners who, the elections were done by the states. These wealthy, powerful landowners would eventually go in there and make a decision as far as who their political party or who they were supporting for president. Nowadays, it's more or less a formality. If you win the popular vote within your state, then your state is given a certain number of electors, which is equal to the number of congressional representatives you have. So the minimum that any state could have is 3: 2 senators, 1 House of Representative member. Whoever wins the popular vote gets all of those electors, except for in 2 cases, which would be Kansas, which has one district that has 1 electoral college vote that's separate from the entire state, and I believe the other one is New Hampshire, which they have 1 electoral college vote that for that 1 district, and then the rest of the state has the remaining. I have no idea why they do it that way. I'll need to research that. But so that's essentially what Electoral College does. There was some concern this time, after Trump won, there was some idea that somehow the Electoral College was going to get together and somehow deny Trump the presidency. There were some people, say, well, that's our last hope to stop. You had this Never Trump movement. We're going to stop Trump at all odds. And there were people who believed that, people on the Electoral College would eventually vote against this person. We knew that wasn't going to happen. Why? Because electors are generally chosen by the states, and they're chosen by the political parties themselves. So, people actually do run to be Electoral College vote. I know a couple people who've served as Electoral College members. And really, it's after the election, those individuals run basically saying, I'm going to support my party's candidate. So you have people, I'm running to be the Hillary Clinton Electoral College vote. And then after the election, they choose those people who end up going to DC, and there's a formality as far as them placing their vote for the candidate that they said they were going to paint. The issue comes up in this case. This one was Chafalo versus Washington. And it's actually 2 separate cases. One case out of Washington, and then I think the other 2 cases came out of Idaho, I believe. But essentially, these individuals basically said that they were not going to vote for the person who won the popular vote within their state. So Chafalo, the guy in Washington, he actually said that he was going to vote for, I know the 2 guys in Idaho were trying to vote for John Kasich. And then the guy Chafalo, he was trying to vote for another Republican, but the general idea was that we're going to support a Republican, and hopefully that way we can get the other Republican Electoral College members to support that one Republican as well. That way Trump doesn't win. But in Washington and in about 33 other states, there's actually a law in place that basically fines you for doing that. If you go there and you vote, you cast your Electoral College vote for anybody other than who won the state popular vote, then you end up getting $1,000 fine, as was the case in Washington. I think the 2 guys in Indiana, they ended up backing down, but they did still file an action against this law. And so what the Supreme Court eventually came back and said was that, the Constitution doesn't really speak much to how electors meet their decision. They just say that they're from the states and subject to the state's rules. And so they basically said, there's nothing in the Constitution that says that states can't do this and say you're going to pledge your vote to the popular, who won the popular vote within the state, or else you get this fine. There's nothing to stop the states from doing this, so it's constitutional. Like, they can do this. So gotcha. A lot of the media is a little confused about this because they're coming back saying, well, the Supreme Court basically have gotten rid of faithless electors. That's not necessarily the case. You can still do it because there's still 33 states that still allow for this, or you could just do it and pay the fine. They're just saying states can put this law in place to fine people. And I will say this is not a case that's happened very often. In the court decision, they talked about how often this happens. And again, it's, they said out of 23,000 electoral college votes in our country's history, you may have had 180 cases where somebody has voted against the person who won their state popular vote. And over 2/3 of those cases came because the Democratic primary candidate died. So he died, they voted for somebody else, even though he won their state popular vote. So this doesn't happen very often. And I know for a lot of people who are trying to push to get rid of the electoral college vote, they're saying this does that. And there's still a way around getting rid of the electoral college vote. A lot of people want to go to a popular vote. And it would be as easy as states saying all electoral colleges that our state get, we're going to give to whoever wins the national popular vote. And so there's actually a movement to try to get enough states to do that, where it doesn't matter what the individual states do. If we get 270 electoral college voting states to basically, pass that similar law, our electoral college votes are going to go to who wins the national popular vote. Then you essentially have gotten rid of the electoral college vote, regardless of what the other states do. By this decision, you can still do that because they basically said states, you can come up with whatever laws you want to regarding how electors are chosen. You can fine them for if they, stray away from these basic laws. So that's the faithless electors vote decision.
Gotcha.
This decision was unanimous. So, I think everybody's kind of on board with it, that we knew this was going to happen.
So how does it affect us? I understand that, the law has been, they're going to enforce this, but how does it affect us, the common folk?
Well, I think, again, this isn't something that we've seen very often. I think that there was a big push, this past cycle, more chatter about it this past cycle than any of I've heard since I've been involved in politics. I guess it hasn't been too long, but as far as how it affects us, I would say that if you are still on board with trying to get rid of the electoral college system, which I think a lot of people are, there are two different ways to do this. Number one would take a constitutional amendment, which I'll say right now is not going to happen. Just the process of amending the Constitution, you need 3/5 of the vote from Congress, 3/5 from the votes from states. Like, we're still trying to get the Equal Rights Amendment passed, which, getting a 35th state on for that. So, getting 35 states to agree to getting rid of to get rid of the electoral college is not going to happen. If you're trying to push to get states to give your electoral college votes to the winner of the national popular vote, I believe that's possible. I think that's a lobbying issue that's possible. It could be done. So for those individuals who are on board with trying to get rid of that system, I think that's the way to go. As far as how it affects us directly, I would say this one doesn't really have that big of an impact. Very rarely do you see again, it's rare that you see a faithless elector. It's rare that you see the person who wins the national vote not win the electoral college vote. It is concerning that's happened more often recently. I believe it's only happened 3 times, but 2 of the 3 times have happened since the year 2000. So, but yeah, I don't think it's going to be that big of a case as far as your day-to-day life.
Gotcha. So at least it's something that we're now better educated on, at least, so that we aren't going around waving the flag of, hey, eliminate the electoral college, when we really don't know just how much of a hurdle it will take to actually enact that sort of a thing.
I also think that, understanding the electoral college decision, because the thing that, when I go out there and I worked on campaigns and, people say, oh, well, it doesn't matter who we vote for because the electoral college is going to choose. well, yeah, they choose based on the popular vote. So you still need to get out there and vote. That's kind of, and I mean, obviously, there's some other issues with electoral college system as far as representation. I mean, you look at California's population compared to Washington's population. California gets 54 electoral college votes. Montana, for instance, gets 3. And one would say, yeah, because California is a lot larger state. But even after you break down that population to how many electoral college votes they get, it's still widely disproportionate that Montana per population gets a greater share than California does. So there's still things as far as representation goes from the electoral college system.
Awesome. Hey, really good info. I do remember seeing a lot of folks saying, hey, you better get out and vote now because you see how this recent ruling did come about. So I guess that's in a sense how it affects us. Our vote, does have significant importance.
Impacts, yes.
Big time. So good opinion, good education. So we got some more comments coming in, of course. Let's go ahead and share some of them. We've got one again from Mr. Sean Lanier. He said, we are everywhere.
That's right.
Okay, Sean. That's awesome. But to back him up, I've got 2 of my frat brothers who jumped in, and we got one from Brother Sutherland. He says, "I'm great that you're doing this to educate the public through Phi. That is awesome." Well, I appreciate you, Mike. And then, I appreciate that. And then I've got another frat. He was a guest on my discussion with the Caribbean connection. Did you get a chance to see that discussion, by the way, recently?
I did not. I'm about to go back and watch that.
Ooh, that one was 2 parts. It was 2 parts. It was on fire. It was on fire. But he says until the fine is more substantive, the infractions will continue, if even to be provocative. I hear what you're saying.
I mean, I question it. I question it because, again, it's not something we've seen. I mean, even in the past 2016, you had 1 electoral college vote out of 545. Like, I mean, it just does not. Or 535. You had 1 person who ended up straying, and I mean, if you look back the past 5 presidential cycles, you may have 3 or 4. So I don't, like I said, I guess they'll continue to happen. Whether or not they're going to have an impact, I just don't see it happening.
Gotcha. Oh, by the way, if you guys, well, maybe I could put this as a banner. Let me do something real fast. I'm going to show you where I can actually go right now, and you can go too right now. If you're interested in learning exactly all the different opinions that's put down by the Supreme Court, let me put this banner up real fast right there on the bottom of the screen. You can see it right now. It says, you go on SupremeCourt.gov, opinions, and all of the opinions are there. This is just 2019's opinions right there. So you can go right now, SupremeCourt.gov/opinions, and actually look at all of the opinions dating back several months now. These all date back to, or is it several years?
These should be all the 2019 decisions. But if you actually go to the Supreme Court opinions page, you can go back far longer. And this opinion was actually written by, I believe it was Justice Sotomayor. And she quoted Hamilton, she quoted Veep. So this was actually a pretty good one to read. Some of them, I will say, reading them is like watching paint dry, but this is actually a pretty well drafted ruling.
Awesome. So let's go into the next one, the next decision here. And this is something that I think is going to affect a lot of folks. So really listen up there, viewers, and really take this one in. The next one that we like to talk about is the LGBTQI+ decision.
Yes. So this is the Bostock ruling. This is Bostock versus Clayton County, Georgia. This is actually a combination of, I want to say it was about 4 cases that have been kind of forced together in dealing with this. And so the background on this case goes back to 1964 with the Civil Rights Act. The Civil Rights Act of 1964, and in it, they basically say that you can't deny somebody public accommodations on the basis of a protected class. Those protected classes were laid out as race, religion, national origin, and sex. Interesting thing about the Civil Rights Act of 1964 was that sex was actually an afterthought. Like it was never actually intended to be a part of the legislation. It was a congressman who was actually trying to kill the Civil Rights Act of 1964. And so he put in sex as a protected it was originally designed to protect African Americans during the Civil Rights Movement, of course. He put in sex as a protected class with the hopes that it would go back to committee and would die in committee.
Who was this congressman? Do you remember?
I will post it on the page. I don't have his name off the top of my head, but he originally tried to put this in so that it would go back to committee, and then he would have enough time to mobilize people against it and kill it. Even though this is one of the fundamental, pillar civil rights bills that Congress has drafted, government at the time it was very, very divisive. The longest filibuster in congressional history was Senator Strom Thurmond, who was actually protesting against this very bill. So they put in sex because, they thought it would send it back to committee. What he didn't realize was that it actually mobilized more people to get on board and got it passed. The problem is now that, I guess the issue is, now ever since the mid-90s, the question has been, what does that mean? What does sex mean? Are you talking about somebody's sex as in their gender? Or are you talking about their sexual preferences or sexual identity? So sex has taken on a more encompassing role as time has moved forward. And so one of the issues that the courts were very split on this. You have a number of appellate decisions which have gone either way on this question. So when somebody is, fired for the purposes of their sexual identity or their sexual orientation, you'll have the 10th Circuit, which says, yes, that falls under the sex discrimination, and therefore it is illegal. And then you've got the, 4th Circuit, which says, no, that doesn't fall under the sex discrimination, and therefore it, and so there's been some push to try to get Congress to actually buy in on this and say, basically clear it up and just add in sexual orientation and gender identity to protected classes. That would make things a whole lot easier, because now it's clearly stated in the language that that's what it is, and it goes from there. But Congress has not done that. They've been fighting that for over 2 decades now, and it just has not gone anywhere. But this decision finally puts that question to rest. And so in it, you have a number of different cases. I know one case that came out of Washington where an individual actually, he worked for the county government that he lived in, and he actually joined a LGBTQ baseball league. And once his employer found out, they fired him. And I mean, his employment record said he was a stellar employee, all of this. And it wasn't until he joined this LGBTQ baseball league that he ended up getting terminated. He brought a suit saying it was illegal. And in it, the court, which surprisingly Neil Gorsuch wrote the opinion. Well, not surprisingly, Neil Gorsuch wrote the opinion. If you know anything about Neil Gorsuch, obviously people will say because he's a conservative, it's odd that he fell on this line. But if you know anything about Neil Gorsuch and his judicial philosophy, which I'm going to touch on a little bit, it actually wasn't that big a surprise that he would be in favor of this. But basically, he laid it out plainly that this was discrimination on the basis of sex. Because, if I'm a man who loves a woman and I'm hired, and somebody else is a man who loves a man and he's fired, how do you say that's anything other than sex? Had it, I guess I put there, if I'm a man who loves a woman and I'm hired, and if a woman loves a woman and she becomes fired for that, how do you say that she was fired for anything but her sex? And I mean, this act, has been used before in a number of different cases, including, sexual presentation or, meeting sex stereotypes. So men who are effeminate or women who are masculine have been found previously to violate sex discrimination if you fire them for that reason. But this kind of lays out plainly and clearly that you cannot fire anybody, or, that people, their gender orientation or their sexual identity do fall under sex discrimination under the Civil Rights Act of 1964. And the reason he got to that decision, so Neil Gorsuch, and what I talked about as far as his judicial philosophy, he is what you call a textualist. There are a lot of, again, we talked about what the judicial system does, and when cases come before the Supreme Court, as far as congressional interpretation, this is a case of what did Congress intend, and that's really the question here. And you'll have some justices who will say, well, let's look at the mind state of the representatives themselves to try to determine what they intended. You'll have others who are textualists, like Neil Gorsuch, and say, just look at the text. They said A, so we're going to give them A. I don't care if they meant B, C, D. It says A, and we need to go by A.
Wasn't Alito somewhat of a textualist himself?
It's so sometimes people who claim themselves to be textualists, like they find a way to use it when it's convenient, and then other times they find a way to avoid it when it's not. And so, so this one was definitely one of those cases where that mattered, at least to Gorsuch. And if you follow Gorsuch, he's been very, very principled about this. If Congress says, this is the law, that's the law to him. It doesn't matter whether or not it's good policy, bad policy. I'm not digging into what people think or anything like that. Now, some of the other justices, they wanted to try to bring up the idea as far as, what Congress intended, but it's hard to do in this circumstance because there wasn't much debate over this provision. Again, this was a last minute add-in that they thought was going to be kicked back to committee, and it wasn't. So, I mean, even if you look at the congressional record, like it's very, very basic on what, sex says, but what they'll try to do is say, if you look at the other laws around the time, Congress has not always been friendly to the LGBTQ community, and therefore we can interpret their mind state to say that they did not intend this consequence. And, the judges have always been trying to kick it back to Congress to say, Congress, you can clean this up if you want to, or legislative branches, you can clear this up if you want to. And then they never do. So, I mean, you do have certain states who have added in gender identity and sexual orientation, but those are in the minority. I think it's less than 15 states that have actually added to their state civil rights statute. But now they've interpreted it this way. I think when you look out, long term on, the impact of this, it not only impacts the Civil Rights Act of 1964, but any law that, has sex in there as a protected class. So, I mean, when you think about, housing, you think about employment, you think about the Americans with Disability Act, go down the list of all of the instances where our government has laid out protections for protected classes, hate crime bills. I mean, if there's a list of protected classes and sex is listed in there, any of those, anybody who is within the LGBT community, they're going to lean on this decision and say, the Supreme Court said in Bostock that I fall under the protected class of sex. And so I think long term, I think you're going to see a lot more equality or a lot more protections for this, because again, this has been a very, very, it's been a very difficult issue for people to understand, because, for a lot of people, they would say, can you fire somebody for being gay? If you ask people now, can you fire somebody for being gay? Before this decision, a lot of them would say, no, you can't do that. It's illegal. Not really. I mean, in North Carolina, you definitely could, because, our state law doesn't have it. Our state judiciary has found that, that if you're gay or a lesbian, you don't fall under, gender for the Civil Rights Act. Now all that changes.
Wasn't there something that came up recently? I think it was like 2017 or 2018. I remember where the All-Star game was pulled from North Carolina and all those.
Yes.
Is that where it falls? Yeah, I thought so.
HB2 was something a little different. Basically, they called it the bathroom bill, but it was far more wide sweeping than that. The city of Charlotte actually put in in their city ordinances, they basically said you have to make accommodations for LGBT community. They banned firing anybody for their whether or not they were a member of the LGBTQ community. And then part of what they were basically saying that public accommodations had to be made for bathrooms. If you were transgender, then you could go into the bathroom that conformed with, with who you identified as. And then the state legislators came in and said, in North Carolina, cities only have as much power as the state give them. Yeah. So the state came in and said, nope, we're getting rid of this. No, not only are we getting rid of this, but cities, you can no longer implement your own civil rights ordinances. Like everything has to come back to the state. And it just it blew up and went, it was all over the place.
Tracking.
Very big black eye for the state.
Hey, North Carolina has an interesting history. I'll leave it at that. That word interesting. So we've got actual questions that's coming in based on this this discussion here. We've got one from another attorney. Hey, Elizabeth, what's up? She asks, are you surprised that the court upheld the Price Waterhouse in this case?
Not really. And actually, the Price Waterhouse case was the case that I talked about as far as gender conformity. And I think in that case, it was a woman who they said was too masculine to get a promotion, or she behaved too masculinely to get a promotion, and she sued. And I'm not surprised. I mean, I think that, again, going back to, Neil Gorsuch's judicial philosophy, I mean, his thing is, what does the text say? If the text says this, then that's what we're going to go to. I think a lot of people have kind of misassumed that because he's a conservative and Trump appointed him, that he's going to fall in line in lockstep, much like Kavanaugh has been doing. But if you watch Neil Gorsuch, I mean, I still disagree with him on a lot of issues, but one of the things I will credit him on is he is very, very principled in his decision making. Like that, he's very consistent about his logical reasoning.
Got it. Thanks for the question, Elizabeth. Then the comment from Asoro, she says, I believe Republican Senator Richard Russell tried to prevent the Civil Rights Act.
That may be. I mean, like there were a lot of the Dixiecrats and a lot of the Southern states representatives were the ones who were trying to prevent it, against Strom Thurmond from South Carolina, Jesse Helms in North Carolina, even though he wasn't in the Senate at the time. But yeah, so I mean, it would not surprise me. I would need to look at, like I said, I want to go back and research the name of the individual who actually put that in there, but it wouldn't surprise me if it was Richard Russell.
Okay. And we've got another comment coming in from Mr. Michael McAdoo, said Kevin Riddle, LinkedIn. Okay, thank you so much. Thank you so much. So I guess the last, and you saw how quick time has just flew by, man.
We're almost at an hour. Time.
And that's a good thing, though. This is a hell of an education that people are getting directly from the ESQ's mouth. So let's go ahead and show the final thing. And I'm hoping this is one that you're aware of and well versed in. It's the Consumer Financial Protection decision.
The case I actually did want to cover with the time we had was the abortion case. But
okay. Let's how about this? Ain't no sweat. Ain't no sweat.
That was another major case that came out of the Supreme Court.
Abortion protection, you said?
Yes.
The abortion protection case. Let's go ahead and add that on right there. Bam. Let's talk about it.
So this was a case that came out of Louisiana. And actually 4 years prior, there was a case that came out of Texas. And what anti-abortion advocates have tried to do was try to get abortion providers to get hospital admitting requirements in order to continue to provide abortions. The problem with that is a lot of those hospitals can't get those requirements because they just don't send enough people to the hospital. Abortion, you look at it, is a very, very safe procedure. And I mean, for a lot of time, unless you're, second, third trimester, late term abortion, for the most part, it's a pill. Like you take a pill, you come back the next day. Like there's nothing that requires any kind of hospital admitting privileges. But for a lot of anti-abortion advocates, they've tried to find ways to be more stringent on abortion providers by doing things like regulating the kind of buildings they were in, saying, your hallways have to be this wide because, if you need to push two gurneys through, they need to be able to pass in the hallway. Well, if you go to abortion, they're not pushing people in a gurney, like, so it's not really necessary. But if you are for abortion, now you've got to restructure your entire building to make sure that it fits these, mundane requirements that have nothing to do with women's health. Same thing with hospital admitting privileges. It's not necessary. If you go to any medical community, they'll say it's not necessary. It's not a necessary provision. It doesn't protect women's health any better. And what it does do is makes it a lot harder for abortion providers to practice abortions because they just can't get those hospital admitting privileges. So the state of Texas, they tried to put in these requirements 3 to 4 years ago. I think the case came out in 2017, I'm sorry, it's 3 years ago. They tried to put these provisions in place and they were struck down. It was a 5-4 decision. It was a 5-4 decision. Anthony Kennedy actually wrote the decision. So since then, we know that Kennedy is retired, Justice Kavanaugh has taken his place, and then we know that Neil Gorsuch has taken the place of Antonin Scalia. So for a lot of anti-abortion advocates, they thought this was their perfect time to go ahead and strike against abortion and weaken the requirements of abortion. So Louisiana put in place a law that was almost identical word for word, like it's the exact same law that they put in place. And the state of Louisiana only has 3 abortion providers, which again, in the entire state, they've got 3 abortion providers. And if this had gone into place, it would be dropped down to 1. There would only be 1 abortion provider in the state of Louisiana that could get hospital admitting privileges. And of course, the state will come back and say, well, we're not preventing people from getting an abortion. We're just putting these rules in place that they just, no provider can get. Yeah. And so they thought that now that the courts had switched, that Kennedy's out, Kavanaugh is in. We know that Kavanaugh he talked at length about getting rid of abortion. That we've got a friendly court. We're going to get back in front of this, and the court's going to strike down these protections. Chief Justice Roberts threw a curveball and basically said, no, like this is the same law. We've covered this. So he got rid of it under it's a judicial terminology. It's called stare decisis. The matter has already been decided. We have decided this. Why are you coming back to us with it again? This is the exact same law, nearly word for word. And, we've already decided this 3 years ago. Now, there are a lot of conservatives who've tried foul against John Roberts. And I will say they have a right to do so because John Roberts' thing is like, we've already dealt with this. We're not going to overturn it. But then it comes back. You've overturned laws before. You've overturned precedent before. You've overturned Supreme Court precedent before. So why is this one any different? There's not really ever an answer to it because even, Chief Justice Roberts was one who wrote the decision. And in the decision, he stated, I thought the Texas case was decided badly. Then he voted, he was part of the 4 that voted in favor of the Texas law. He said, I thought it was a bad case then. I think it's a bad, I still think it's a bad case. But because we handled this 3 years ago, we're going to keep it in place. But again, it comes back to you've overturned Supreme Court precedent before. So why is this the issue that you're going to say that you're not going to do? There are a lot of people who are saying, who believe that, one of John Roberts' driving convictions is to try to make the court seem as impartial and nonpartisan as possible. And so there are a lot of people who think that this decision is tied to that. We don't want to politicize the court. And obviously, the only reason that this decision would be decided any differently than the one 3 years ago is because who the president is and who he had a chance to appoint. And I think John Roberts is afraid of, I guess, people perceiving the courts as being partisan, as being partial. And so he went with this to try to, I guess, dissuade that notion.
But we see typically when they talk about decisions and rulings that are done, we see the words conservative Supreme Court justices and and liberal conservative and liberal court justices. So how could you break that if you have these labels out there already?
Well, I think that a lot of that's just public perception. I mean, so there's a lot of ideas as far as, if you were appointed by this president, then you're going to lean more this way. And one of the things I will say that, I think that it's starting to get more partisan now, but historically, when you look at the justices, it's kind of hard to, separate, conservative presidents, and conservative judges. Like that has not always been the case. Some of our more liberal judges have been appointed by Republican presidents. I'm thinking like Hugo Black was, one of our leading liberal judges, and he was appointed by a Republican. But so I mean, I think that disconnect has always happened, but I think now, especially with how politicized we are as a country, you're starting to see that. And I think that you start to see that from organizations, when you have organizations like the Heritage Society, which their whole thing is, conservative judges. We want to judge to strike down, abortion rules and LGBT rights. And when they get in the president's ear and the person running for the Republican ticket says, I'm going to go and nominate Supreme Court justices based off of this list that the Heritage Society gave me, it's kind of hard to separate that from from the idea that judges are now being politicized. And I think Robbins is trying to fight against that, even though the country as a whole is beginning to get more partisan. The country as a whole is getting to get more political and divided. And I think Robbins is doing the best he can to try to avoid, people seeing the court in that same light. I don't know how well that will happen, but I do know that for a lot of abortion advocates, anti-abortion advocates, I know this is a case that really hurt them and really upset them, because they thought that they had the courts. They thought this was going to be their time. They could finally get rid of Roe v. Wade. Yeah. Now, some of the things the court has not done. There were some challenges to qualified immunity. Anybody who is involved with, looking at what's going on with policing, know the impact of qualified immunity. There were some cases before the Supreme Court over qualified immunity that the Supreme Court turned down.
Hold on. Don't talk about it, because that may be for a future discussion that I may invite you.
That's fine. I can go an hour on qualified immunity, but another one is they've actually turned out all gun right cases as well. So there were a lot of people who thought that they were going to pick up some Second Amendment decisions. They've actually rejected all Second Amendment cases for the next term as well. So it'll be a while before we see that back in front of the courts.
Interesting. So we've got comments coming in from this last discussion here. And she said, thank you for calling them anti-abortion because they're not pro-life. Interesting. Thank you for that.
I wasn't even doing that intentionally, but
it's excellent, man. Excellent. Antoine, I'm going to tell you this, man, there's just some people that I just enjoy having a discussion with, even if it's not about law. Just I like to see when people come and just talk and explain and show their wealth of knowledge on topics. And you're definitely one of those guys. And I just got to say, thank you for coming and just talking with me today. And of course, in closing, I'm going to let you just go ahead and share whatever you've got going on right now, and people could come. And where can people follow you? People could check out your comments and your comments. You should probably start a podcast, man.
I have been told that a lot. I just haven't done it. So I mean, I do try to lay out as much as I can as far as explaining and breaking down laws and policies on my Facebook page. It's Antoine Marshall on policy. It actually was my campaign page until I lost, but Antoine Marshall on policy. I do try to break down, qualified immunity, the Supreme Court cases, Kanye not running for president. So how we know Kanye is not running for president.
Did he miss certain dates or something like that for filing in like Texas?
Yeah. There are 6 states: Texas, North Carolina, Maine, Indiana, New York, and New Mexico. He's already missed the deadline. California, Florida, and it's California, Florida, and Illinois. I think they're in like 10 days, and he's got to get like 130,000 signatures. It's not happening. Like, he's not even going to be on the ballot. And I mean, he would also have to file an FEC filing, which he has not done. So, it's obvious he's getting ready to drop a new CD. So if you're into Kanye's music, this is a good sign for that. If you want Kanye to be president, it's not happening.
Yeah, I kind of stopped listening to him a while ago, but it is what it is. But, Antoine, just want to say, hey, thank you. I know you've put out the plug there as far as what you've got going on and where people could come and check out your work. Hang out in the broadcast room and we'll talk a little bit more, okay?
Not a problem. Thank you for inviting me. Anytime you invite me, I'm here.
Hey, man, you're probably going to be back next week to talk a little bit about, we talked about Supreme Court stuff, but I want to talk about some of the regular stuff that's going on. And I know it's going
to be. I got you.
I got you, man. So hang out in the broadcast room, all right?
Not a problem.
All right. So in closing, we've got another good discussion there the past hour with Antoine. He's awesome. He's phenomenal. I really enjoy having the discussions there with him. As you see on the bottom of the screen there, it shows where you can go and read up on Supreme Court decisions and actually figure out, okay, these are the things that's going on. Yeah, it's not typically popular in things that's really going on in the news, but it's something that's important and it affects your everyday life. Whether you're a military, civilian, community leader or not, it's there and it's affecting you. And as I always say in closing, take care of yourself, take care of your family, and take care of others. Bye now.